our discussion of marital property. In the last class, we explained that there are two types of marital property laws in the United States. There's community property, which we have here in Texas, and there is the common law system, which we have in New York and other states. Today's class focuses only on common law, right? Today's class focuses only on common law. We will not be talking about community property today. We'll be talking about community property on Thursday. That matters because a lot of the things we're covering today only occur in common law states. So don't ask me about community property. We'll get there next week, next class. All right. All right. Let me take a step back. In this class, at least, when we talk about marital property, I really care about 2 points in time. When one spouse dies or when there's a divorce. What happens during the marriage, I know this sounds dreadful, is really not my concern. And it's not the court's concern. Courts will only very rarely get involved during a marriage. The only examples, or the only exceptions, I should say, are things like abuse or neglect, those sorts of things. Along with abuse or neglect, courts don't really care how couples allocate their finances. They don't. They don't care whether they have separate bank accounts, the same bank account. They don't care if they split the expenses or one spouse covers everything. They don't care if one spouse gets an allowance or if one spouse works. It doesn't matter to the courts. It only matters at time of divorce or upon the death of a spouse. Okay? We'll be talking about divorce today. We are not talking about custody, right? Custody is an entire other area of the law that is separate from our focus, right? In order to get divorced, if there are kids involved, you don't divide the assets up until the custody decisions are decided. Why? Very often, caring for the child requires money, right? And how you allocate the money in the divorce will decide who gets to raise the kids. So, to finalize a divorce, you need to finalize who gets the kids and when. That is not my concern. In fact, in the case today, all the cases will be there's no children involved. We'll talk about kids in death, right? If there are children and heirs for death. But for divorce, we're not concerned about whether kids are involved. Any questions so far? All right, let's provide some history. And I think I covered this last week, but I'll repeat a little bit of it. Historically, divorce was only available when someone wrote over the board today. When it was initiated by the husband. Wives were not permitted to petition for divorce. There were some rare cases if there's abuse, but generally divorce was only instigated by the husband. One of the reasons why women generally weren't petitioning for divorce was because if they got divorced, they could very well be left destitute, that is, poor. In the common law system in England, husband and wife, in theory, had separate property. So upon the divorce, the husband would keep his property and the wife would keep her property. Sounds great, but if you remember, at common law, women didn't actually have their own property. They couldn't earn income, with the exception of inheritance and other things, separate property. So upon divorce, the wife was basically left with zero, with nothing. Over time, that system changed. A system was developed called alimony, what we now call spousal support. The purpose of alimony was to create some sort of regular payment from the husband to the wife to sustain the woman. And the notion was the woman didn't have a career, didn't have an education, did not have a means to provide for herself. So the alimony was meant to protect the woman going forward. All right. Today, alimony is different. Today, we presume that even if you were a married person, you have the means to provide for yourself. You can work, get a job, etc. Spousal support, as we call it now, is meant as a bridge. To basically bridge a person from the separation to being sustainability. Spousal support does not last indefinitely, does not last forever. Okay. The most complicated part of divorcing is dividing up the assets, right? Marriage often end, right? You can look at statistics. Roughly half of the marriages end in divorce. It depends who you are and your income. Higher income, usually there's less divorce, but it varies. Okay. Now, how do you actually get divorced? Well, it depends. Do the two partners agree or disagree? Today we have what's called contested divorce and an uncontested divorce. If both parties agree they want to separate, they can file what's called a uncontested divorce, which makes it easier for the courts. Some divorces, though, are contested. The parties do not agree. That is, one party wants to stay married and the other one doesn't. Those become much more difficult because basically a court must force a divorce over the non-consenting party's objection. Even with an uncontested divorce, the parties can still contest how you divide the assets, right? You say, we want to get divorced, we agree, but, we don't agree on the assets, and they may still end up going to court, right? Now, on what grounds can you get divorced? At common law, back in the day, you could only get divorced if there was fault, F-A-U-L-T, if there was fault. What does that mean? If one of the spouses screwed up. Usually, almost always, it was adultery, right? If one spouse committed adultery and you proved it, which is sometimes harder to do, that was a ground for divorce. Abuse, I'm talking physical abuse, not mental abuse is more of a recent thing. But if it was physical abuse, beating, that was another ground for fault divorce. But you would still need to show evidence to a court to demonstrate it. Now, I'm just making this point bluntly. Battered spouses were not the best at persuading courts back in the day of having evidence for it because there were risks to go forward because you might get nothing out of divorce. The modern trend, though, and in fact, every state has this law, is to no longer have only fault divorces. In the 1970s, states began to experiment with what was called no-fault divorces. California, I think, was the first state in the union. What's a no-fault divorce? Couples can get divorced for any reason, no reason at all. They don't need to give a court a reason. You always see in Hollywood, the couple split up for reconcilable differences. Right? You see this phrase? What does that mean? It means absolutely nothing, right? It means they don't have a reason. They don't want to give a reason. They don't need to give a reason. They just say we have differences and we're going to separate. The upshot is one spouse can petition for divorce without any fault or any reason, and the other spouse can't really stop it, right? The court is not going to force you to stay married. Good. The judge will say, you know what? I don't believe your fault. I don't believe there's a married. Right? That was entirely plausible. Right? That's not his kid. There was no Maury Povich back in the day. Right? Maury's going off the air. Did you know that? No more Maury's going off the air. You know Maury Povich is? Oh my goodness, these guys. He's a TV show, and his entire bit is he does paternity tests. Like, are you the father? Yes, you're the father. You are not the father. Yes, okay, now you know. The best one, just it's a meme where he tells the guy you are not the father. The guy does a backflip, a standing backflip right there in the spot. He's so happy. It's like, I told you it wasn't mine. I told you it wasn't mine. Anyway, back in the day, there was no Maury Povich, so even proving adultery if there's a child in tow is not always possible. All right. So what happens upon divorce? Right. We don't need fault anymore. So you tell both couples says, I want to get divorced. We don't want to have this marriage anymore. And then you get to the hard point of what happens to their property. Right. Again, I don't care about spousal support for children. Right. The child support is a different area altogether. All I care about is what happens to their property. Well, there's some easy things that happen. If they had a joint tenancy or a tenancy by the entirety, it becomes a tenancy in common, right? That's the easy one. So now the two partners, the husband and wife, are tenants in common, and they will probably either sell the lot or they will just sell their interest to somebody else. If there's a difference in earning potential, the court may award spousal support, which again is not going to go on forever and ever. It's designed as a temporary bridge to get a divorced spouse through the hard times. If the spouse gets remarried, then they probably lose the spousal support to someone else's problem, so to speak. Have either no fault divorce or it's called modified no fault divorce. So, for example, in Texas, you have to wait 90 days. So if you file for a divorce, you can't get it right away. You have to wait a few months. In Virginia, where I went to law school, it's even longer. I think it still is. I haven't changed it. If you reach an agreement on how to separate property, it takes 6 months. If you can't reach an agreement, it can take a year to actually petition for a divorce. Why do you have to wait so long? To make sure you're serious about it. The law hopes, maybe naively, that if you give someone time, they'll get back together. They will rekindle the relationship. They will reconcile. They will find they actually want to be together. The upshot is you are stuck with the person for a year and you can't get divorced and you can't get remarried. And you can't move on with your life, so to speak. So it really does force the person to stay divorced for some period of time, 3 months, 6 months, 1 year, where they're basically still stuck as married. And it does go on in some states. California, I think you can get divorced right away. There's no waiting period. But even in places like New York, you have to wait months to actually get a judge to enter a divorce decree. So it's not automatic. So when I say 6 months, that means 6 months to file. And then even then might be another few more months till the judge gets around to enter your docket. And this is a general matter. Courts across the country are so backlogged because of COVID. Like, I don't know when a judge will ever catch up with their business. So it might take a year to get a divorce decree. And that time you're still legally divorced. Any debts your spouse assumes are your debts. Oh yeah. Any obligations you have to a spouse resume. So think carefully before you say I do, right? Think carefully. Yeah.
If you were to somehow get married during that period, would that be considered
bigamy? You could not. Right. When a person says, "Oh, I'm separated," that doesn't mean anything. It doesn't. You're still legally married. So yeah, they can't divorce. I'm sorry, they can't get married during that interim.
This seems kind of archaic. It sounds fairly.
Well, think of it in the common law, right? Children who had unmarried parents were basically called bastards. They had no legal rights. The law was designed to keep parents together. I mean, I made this point last week. Marriage existed not for love, not for happiness, but to keep children together. And if the starting presumption is you want your children to be together, that's archaic. But today, where a kid can have one parent, two parents, three parents, whatever, right? It does seem perhaps a little bit outmoded. I don't know if Virginia still has a 6 month, 1 month rule. I think they do, but I got to double check that. Yeah, Daniel. All right. Annulment, though, is if you get divorced. I'm sorry, if you get married within a fairly short period after the wedding, you get it basically wiped out. I think it's got to be within a week or two. It's not a very long period. This is like a whoopsie marriage, like after the Grammys, you go to Vegas, right? It happens. You're Kardashian, you do it. No prenup either. Yeah, go ahead, Gabriel. No, it doesn't. You do not need to. If you know what that means, Google it. Right? The laughter, you know what that means. Right? No, there's no obligation to have any physical. You don't have to live together. Right? But the trickier part is to go back to Daniel and Tony's question. In some states, if you want to get divorced, you can't live under the same roof. You have to actually move out, and you have to move out for almost a year and a half till you can get remarried, and that there are complexities. Getting divorced is not easy. Getting married is real easy. Yeah, they make it real simple. Breaking up ain't so easy. It's not like an efficient breach. I know this class is so dour. You're also bright-eyed. Oh man, everything's love and marriage, right? Yeah, okay. Now you get to property. Everyone with me so far? All right. In virtually every state, when you're talking about division of property, you have what's called equitable distribution. Equitable distribution. Okay. What is equitable distribution? Well, it's not equal distribution. It's not you split it down the middle 50-50. It's equitable distribution, which suggests principles of equity govern. Okay? You know, yeah. Everything I am talking about today is common law. Again, I think I mentioned earlier, everything today is common law because the rules are going to be a little bit different in community property state. The idea of equitable distribution is only for common law states. I mean, you have in all states, but it's a little bit different. Okay. With equity, the court will divide things up according to principles of equity, as the name suggests, which means based on fairness. Perhaps one spouse did more work to contribute to the household, and the other spouse perhaps did more work to contribute to the financial implications. Courts can weigh those factors when they're allocating property, right? It's on an equitable distribution. All right. Now, here comes the hard part. With equitable distribution, you're equitably distributing what? Marital. Yes, marital property. Someone said it. Yeah. With equitable distribution, you're dividing up marital property. For divorce, the courts will only chop up marital property. For death, different story. We'll get to death later, right? Death is a different story. But for divorce, the court can only divide up marital property. So then becomes the hard question for all of you. What is marital property? Or more precisely, what is not marital property? Because in any dispute, one spouse is like, oh, that's marital property, right? The other spouse is like, no, that's not marital property. And the court has to decide. So try this one. See if you can define in one sentence. One sentence. So you guys do. The other class, a little bumpy. What is marital property? What is marital property? I think you'll see there's a hard things to find. All right, who's next? Where? Sarah. Okay. Oh, last one. We went done. Okay, that last one before they finish the class. Good. Good. All right, another 10 seconds. I'll call on Sarah. All right. Let's give 5 more seconds. All right, Sarah. What's your definition here?
I put property and assets purchased by both husband and wife during the marriage.
All right. So now you're gonna hate me. Follow up. What do you mean by purchased?
By purchase, collectively made a choice to purchase said property.
So if the husband buys a car and the wife doesn't know about it, is that marital property?
Depends on whose bank account it came out.
Oh, do you want to revise your definition?
Yes. So property and assets purchased with money from a shared bank account by both husbands.
So if they have separate bank accounts, it can never be marital property? We have to. Yeah. Thank you, Sarah. Cade, what's your definition?
Mine was property that was jointly bought and owned during the marriage.
Bought and owned. Okay, so I think Sarah talked to the purchase part. What do you mean by owned? What does it mean to be owned?
Well, I kind of meant it as like
kind of like mixed between the two. So it's like both husband and wife have like, I guess, interests or something in it. It's like both of theirs.
But so again, if the husband buys a car from his own bank account, is that marital property?
I don't think so.
Okay. And what if that bank account is used to pay for, their mortgage and other joint expenses? What if the husband withdraws money from his single bank account to pay for the mortgage for their house?
What if the house is bought like with both money? Then that would be joint.
Right, but I'm saying that's the bank account he's using. But he uses that same bank account to buy a car.
No, I don't think that'd be marital property.
What if the wife deposits some money in that bank account every month to help with the mortgage payments?
Well, then wouldn't that be like a joint bank account?
No, it's his, but she sells it, right? Transfers it.
I'm not sure at that point.
Monet, what do you think? What if the wife puts some money in the husband's bank account each month to cover the utilities?
Yeah,
Yes, what?
marital property.
So then if the husband uses a separate bank account with the wife's money, it's marital property?
Yeah.
Even if the wife had nothing with the purchase?
Yes.
Okay, so what's your definition, my friend?
I have property obtained during the marriage, not including gifts or inherited property.
Okay, so you said obtain. Gifts and inheritances are not marital property, so that's actually very good, right? If something comes from a gift or inheritance, that is excluded from marital property. That's like the easy one, right? So I'm glad you brought that, Monet. Very good. Everything else is really tough. All right, so I think Sarah and Cade made some fair points. Let me try to distill it down. There's not a good definition of marital property. I mean, you can look it up in the dictionary if you want. That's all good, but it's very hard to define. Marital property refers to things that the couple acquires, has an interest in, purchases, and so on during the marriage. There's no single definition. And if you read the Colorado case, Graham, the court says it's a very broad concept. The reason why it's so broad is that when you're married, it's tough to keep things separate. And again, I'm not talking about Texas. Texas is community property. It's even tougher. If you're in New York or New Jersey and you're married, it's hard to keep your affairs separate when you're married. You might try, and maybe you succeed. Maybe some people are just very good at separation. And I'll give you a simple example of what I was giving to Kate and Monet a moment ago. Let's say each spouse has a separate bank account. Okay, that's good, right? But then, like any family, you have joint expenses. You have to pay the utilities, right? You have to pay your electric bill. You have to pay your mortgage, etc. And I suppose it's possible that each spouse sends in a check for 50% of the amount each month. But it's more likely that maybe one spouse might cover the expenses 1 month and say, oh, hey, sweetie, can you just, transfer me, however much money for half of it? Oh, yeah, sure, whatever. Oh, guess what you guys just did, right? You may have started with a separate bank account, but you commingled. You know what commingled means? When you mix, right, to commingle. You commingled your funds. And that may actually transfer the bank account instead of it being a separate account to being one that's joint. I mean, it's not titled as a joint account, but might be considered marital property. The way to actually do it, and some couples do this, they actually have a third bank account that's neither of theirs. And the sole purpose of this third bank account is to pay bills. And then each partner transfers money to this third account, X dollars each month, and that's where the auto debit goes, right? That's where the automatic bill collection goes, right? In order to actually keep separate property in a common law, you have to work very hard. You have to create, somewhat elaborate structures to avoid the commingling of funds. Because once you do it once, that might be sufficient to forever taint that bank account. Think, well, wife put in $100 there. Who knows where the $100 went, right? Maybe it was done for something. Andres.
What name is that third bank account under?
It will be a joint account, both their names. But that will be marital property. In other words, that is marital property by choice. And then each month, both spouses put X dollars into that account to pay their shared expenses. So in the event of a divorce, you would equitably divide that joint account, but that's what, they put only in there enough to pay the bills. It's not their savings, right? If you have a mortgage, right, even if you're both paying the mortgage separately, that's probably going to be considered marital property because you can pay it together. What I'm trying to get at is if you're married, just about anything you have could become marital property if you're not careful. And most people are not careful enough to keep things separate because it's a lot of work, right? I mean, how much extra work is it to have a third bank account with this and that? You just transfer me whatever at the end of the month. Or you have a single bank account, which a lot of couples do, and they don't even think about it. Kevin?
Does it also work with companies? Like, a certain amount of money or an asset into a LLC rather than your own, under your own name, 6%, so that the spouse can be able to cover it.
Say your question again. I think the last part about the spouse took me for a loop. Just one more time.
I've known that sometimes you can transfer an asset, whether it be a house or a car,
Right.
but if you instead buy it through your company, like an LLC, that you're
Oh, to shield it from your wife?
right.
Does your wife ever drive the car? She put gas into it? She ever does maintenance on it? Take it to the garage, get new brakes? You see I'm getting it, right?
Yeah.
It's very hard to actually keep something not marital property. I mean, seriously, if she puts new brakes on it, right, with her own money, she filled the gas up, she put new oil change, she ever paid the car insurance, right? It's extremely difficult to keep property separate. It's very easy to merge, right? It's but getting married is easy. Creating marital property is easy. Keeping it separate's not. I mean, Kevin, what you would actually need is a written, informed contract from the wife saying, "I express no interest in this car. This is not marital property." It's basically you might call a postnuptial agreement where you decide how to allocate your property. Yeah, Daniel.
That was the real property.
So if one spouse buys the entirety of a house, all the money, but the spouse live in the house.
It could, but living in might not be enough. But if the spouse takes some of her separate money and contributes to it, it might be sufficient. Right? Again, the rules are tricky. I'm being somewhat like just very vague about it because the rules are very particular. But if you're in a marriage and both spouses are putting money into something, there's a good shot a court later says it's marital property. You may not know. I mean, we're talking, let's say you have a 25-year marriage and they get divorced 25 years from now. Who the heck knows what a court's going to do and decide, oh, that's marital property. Remember, like in 2017, you put new brakes in the car? Okay, that's marital property. You don't know. Yeah, Andres.
Monetary interests out here, but what about adding women to the house by dividing our children or something like that?
No, that doesn't count actually. No, I'm only being slightly facetious, but it's generally money. Right. I mean, look. I mean, I suppose if there's a family farm and you work on the farm, that can be considered labor. So that would probably be, but just like love and joy in the household, that's lovely. But no. Leaning might be different. That's different than love, right? Because then you actually are maintaining it. But I think it would have to be something above and beyond what a spouse is expected to do. Yeah.
Is any transfer of money into their bank account, like if any
It
amount?
could be. Again, I'm being very vague because you don't know what a court will do in 20 years, right? But I'm saying by making that single transfer, you might risk converting something into marital property. It's a risk. Yeah, Sophia.
So in Texas, you couldn't even.
I'm not talking Texas. Texas rule is this is all common law. Texas rules are very different. It's actually in Texas it's even harder to keep stuff separate.
Yeah, but just like, can you answer just like the random?
I'll be happy to answer your question.
You can't like avoid this whole situation even by not getting married because they kind of like presume you're married off.
Well, there's common law marriage, right, which exists in Texas and other states. So even if you decide not to get married, a court can later say, well, they were effectively married, so they have marital property. Damn, yeah. Right, I'm telling you, it's very hard to get out of this. It's easy to get in. Yes.
So now I'm kind of thinking about like, what about like somebody Venmoing somebody money nowadays? Like, let's say not like that kind of.
Look, you could commingle an account by Venmoing. Yes. Jesus Christ, yeah. Look at these guys. They're never getting married now, right? I mean, look, what I'm trying to get at is it's hard to keep stuff separate. That everyone get that at least that basic point. I'm not saying that a single Venmo, might be sufficient to commingle funds, but you risk. Guys, class here, okay? But you I know it's very upsetting, right? But you risk a lot by making a single transaction. For most couples in the day-to-day, they don't think this way, right? They're not worried about it, and it might just bite them 20 years later. They get divorced. So maybe just don't get divorced. Maybe that's the answer, or don't get married. Yeah, one more, Cade, and then Jason. Moving on.
Isn't that one hypothetical you gave me where the wife like sends money to the husband? Does only the husband's account become joint property or joint marital property, or the wife's account?
Well, the example I gave you, if it's going from one direction from the wife's account to the husband's, and that'd be the husband's become it.
And the wife's is separate.
I mean, you're assuming the never sends the wife money.
Okay.
I mean, it's like, hey, honey, here's $20. Go buy some groceries. That's what you just did, yeah. Here, take my credit card, take my debit card, right? I mean, my point is, I'm not saying those are enough, but in just day-to-day things that people do as a married couple, they risk merging their finances. So it's hard to actually legit keep them separate. Jason, okay, then fine, Carissa.
The couple is given like an anniversary gift.
Gifts are different. Well, it's a joint gift, then they would each have at least, I think, half the value of it.
So that would be like
No, they would each have half a share in it. It would be marital property because that would be equal distribution, not equitable. Chris, the last question. Then I want to move on.
Like, I guess some of that.
Of course you can, but if you act inconsistently with the prenup, you might actually trump it. In other words, if your prenup says we will keep everything separate, and then for 20 years of marriage you start mingling and commingling and things, then okay, the prenup's not really very effective anymore because you chose to obviate it, right? You with the prenup, you can't predict how your relationship will develop and how you'll have family finances. Okay, fine, Trey. Then moving on. Last question, please. I gotta move on. I'm not gonna give you one. Oh, commingling. Commingling. Okay, sorry. I think you wanted marital property. Commingling is when you have two different accounts and they mingle. They money goes from one. When you have two accounts and money goes from one to the other and back and forth.
they like merge separate assets and marital property.
Merging's a little strong, but just even money moving back and forth. Because merging suggests the two accounts become one. So when you use merging, I mean, look, you'll learn the word commingling in law, right? When you have a law firm, each client gives you money, right? It's called a retainer. Each client is a separate account. Client A, client B. You basically have hundreds of bank accounts. They're called trust accounts. It is illegal to commingle funds, to take money from account A and put it to account B. Right? It's like, oh, my client gave me a $50,000 retainer. Let me just take a little bit out, pay for my bills, and I'll put it back in at the end of the month. No. That's the easiest way to get disbarred, right? If you want to lose your law license, trust me on this one. The easiest way to lose your law license is to steal client funds. The easiest way, because it's provable, right? You can see, there's bank account. He made a withdrawal without permission, disbarred, right? That's the easiest way to lose your license. Every month they publish the bar journal. People getting disbarred, just skim it. It's always going to be client funds, client funds, client funds. Commingling, that's what they call it. It's a fancy word that means stealing, right? Don't do it. I don't care how broke you are, get like a loan shark or something. Don't take it from your client, right? Because you're going to get burned. Don't go to loan shark, but payday loan, whatever they call them, that, right? Just do that. Don't take it from your client. That's a bad idea. I want to move on. Any other questions? I appreciate how active you are, but I need to move. All right. So let's go into the first or the only case today, Graham. So this is that case I mentioned. That is it a hand?
No, oh my God.
Okay. That's okay. All right. So this is a case where the court tries to figure out what is marital property. Samaya, are you next? I think you are. You want to give me the facts, please, and Graham?
So this case was about the wife was in position with her husband as the respondent.
Okay.
It was a 6-year marriage. The wife was considered the breadwinner in the relationship,
Yeah.
while the husband was part-time to pursue 2 degrees, a bachelor's in science or something of that nature, and an MBA. And he received a job after, which increased his earning potential.
Yeah.
And contributed 70% of her 70% financial support during the marriage. In her petition, the court makes it clear that she did not petition for maintenance. There were no marital assets accumulated in the marriage.
Okay, very good. Thanks so much, Jasmine. All right, so here we have, kind of a sad situation, right? I don't know if it's sad, but from your perspective, but it's a predictable situation. Couples married in 1968. At some point, the husband decides he's going to go back to school, or at least go to school, get his bachelor's degree and his master's degree, which takes about 6 years. During this time, the wife works as a flight attendant, which is not an easy job. Especially in the 70s, it was not a pleasant job. She's working full time, 40 hours a week as a flight attendant, and doing various other household chores and other things, which the court didn't put into its math, right? The court didn't factor in its weird calculation. I'll get to the calculation. But the court didn't factor in how much time was spent to the actual household chores. The husband spends a lot of his time at school getting his degree, and the husband also spends time with some part-time work. Now, Tamika, let me ask you a question. What do you think? Why do you think the wife was willing to sort of soldier on and put the husband through school, working her butt off all these years? Why do you think she sort of went along with this deal?
She thought there was longevity in the relationship.
Yeah, what do you think was going to happen after the husband graduated from school?
Well, he was a job at the time, and like she would be able to take a load off from the time period she.
Yeah. Did that work out for them? No. All right. What was that? Oh, sorry about that. Okay. My tripod fell. Right. So at some point, this married couple had to have a discussion, and it's like, sweetie, I want what's best for us. I want what's best for our long term. We're in this together. If you help me, I'll help you. You work, I'll study, and at some point in the future, it's going to be amazing that I'm going to have these degrees, and you can relax, and we can start a family. Not right now. Not right now. And it'll be great. So, being the spouse of a grad student is hard in general, right? Because we're all awful, right? No, because we have to study so much, or at least we're supposed to, right? I asked in the last class who says 40 hours a week. No one's hand went up. I did. I was doing at least 60, right? But in theory, at least, there's a lot of stress in this relationship. But at least there's a brass ring at the end, right? There's a shiny rainbow at the end of the rainbow, or the shiny bucket of gold at the end of the rainbow, where the husband will have this massive degree and will be able to make all this money, and it'll be great. So they go through the years of relationship, and then shockingly, magically, like the guy gets his diplomas, like adios, wife, right? He divorces her right away, right? And this is not uncommon. I think I mentioned this in the last class, but I'll repeat it. Like I had a classmate. It was a husband and wife, and they had this plan. They both wanted to go to law school. So the wife would go first, and the husband would work for his wife through law school. Okay, and then when the wife graduated, she'd be making big bucks as a lawyer, and would put the husband through law school. Right. So the husband said, "You go first, sweetheart. I'll go second." So anything happened after she graduated law school? She divorced him, right? And she had a very high-paying job after this, and he was then stuck in law school as a 1L without the income. Anyway, so he made well for himself, but he actually tried in the divorce to seek the tuition dollars he had spent on her, and he got nothing because they said that's just you agreed to pay tuition. It's not a binding contract. It's like the case with the wife and the stroke. Remember where he said to take care of the spouse? That's you made an obligation to your spouse. You're covering her tuition. You can't recover that. So he basically paid her tuition. Then he was on his own for 3 years. So he made out okay. Nothing bad happened to him. He made out okay. But it's a very common story, which then speaks to, of people going to law school, being supported by a spouse, and then shockingly after they graduate, they get divorced. And just to put a little more specificity, when you're in a relationship, sometimes it's stressful because of law school, right? It'll be better after law school. It'll be after school, right? Because the stress will be gone. No. What comes after this is even more stressful. I hate to break it to you, right? The law school is easy. You're here, you're chilling, you have 90 minutes of class, it's fun, right? You get to have lunch, right? You get to see friends, you have barristers ball, right? All these lovely things. I've never actually gone, but I assume it's fun. Right, I don't like dances, right? But the what comes after it's even more stressful. So the husband's like, whatever, this is great, it's nice knowing you. let's divorce. So divorce was not contested, right? Because I think also the wife may realize this is not working. Let's get out of this. The only thing that was contested was the division of the assets. Now, Samaya, I think, said a minute ago there was no request for spousal support. Maddie, why did Miss Graham not request spousal support?
Well, because in the state of they were in Colorado,
Correct.
she wouldn't be eligible for spousal support because she was able to support herself.
She could work. Correct. Right. What a weird rule, right? If you work, even for, I suppose, minimum wage, you're not eligible for any forms of spousal support. So there was no property acquired. There's no house, right? There was no retirement accounts. There was no savings accounts. There were no assets to divide, right? Half of zero is still zero. The only conceivable asset was his business degree, was his education, right? And she wanted to have equitable distribution applied to his education. And we know why. That was her only shot. She had nothing else to do. Now, I said this earlier, maybe I shouldn't have said it. If the wife was smart, she may have hung around for a couple of years and not got divorced right away. Let them buy a house, right? Let them buy a car. Look, it happens, right? But she was like the bigger person, said, "You're right, honey, you don't want to be divorced? I'll get divorced right away." And she got bupkis for it. Go with nothing. Oh, plus attorney's fees, because she had to pay her own attorney's fees. So the wife did not make out well here. I don't know what happened to her. I should try and look up. I've never done that. But she did not make out well here. All right. Guys, response to say, raise your hand, please. All right. So Armin, let's talk for a minute, right? How do you calculate what a business degree is worth? And I don't want the math in the court, but in general, how would you calculate what a business degree is worth, an MBA? What are you looking to see?
How much you can make after the business degree versus how much you make before.
Correct. Right. So this part is actually not that controversial. You can calculate the value of a degree by comparing what would a person with a 4-year diploma make, a 4-year college degree over a lifetime, versus what would a person with this degree plus an MBA make. And the court says about $180,000. There was a study done about 10 years ago for law degrees, for those curious. On average, a law degree adds about $1 million to your salary of your career, which may sound like a lot, but it's really not if you factor in inflation and the fact that this is over the course of a 40-year career. It's actually not that much, but it does add a bit. Most lawyers increase their salary by going to law school. Not all. I made this point some years ago. I got in trouble. People were not happy with me. But for some lawyers, they make roughly the same what they would have made with a 4-year degree, and maybe even a little bit less. They might choose to do pro bono work. They might choose to do, low income representation. So I said in class once, for some of you, you are not making a decision to make more money, right? It's actually maybe been better off if you never got a law degree. And I got in trouble because people got very upset with me when I said it. But it's true. It's not everyone will make more money as an attorney. Most of you will, but not everyone. It's true. Okay. Oh yeah. So one other example. If you know the name Wendy Davis, she ran for a number of offices. I don't think she's won any of them yet. She keeps running for elections in Texas. She went to Harvard Law School while she was married, and her kids were back here in Texas, and she was going to Harvard Law School. Her husband raised the kids. She filed for divorce after the last student loan payment was made. So after her husband paid the last student loan payment, she filed for divorce. This came out after one of her elections a couple of years ago. Actually, before the election, I think. But anyway, so look, I'm telling you guys, it happens. People are rational. They respond to incentives. If someone's offering to pay for their degree, they're willing to suck it out, and then when they're not, they're not. So, okay, I'll leave it there. All right, let's walk through the trial court opinion. All right, and this is kind of weird. And if you don't understand this math, I don't really care because it's wrong. But I at least want to just show it to you. It sounds awful, but it's true. But I just want to show you how the court sort of reaches conclusion. All right, so the court said first, the value of the education, the value of the master's degree, is about $180,000 over the course of a career. And that's assuming a person, let's say, in their mid-20s now, they work for about 40 years, so you stretch over, actually, he's a 30-year estimate, right? So let's say he's like about 30-something, and you have a 30-year career. I guess careers were shorter back then. Okay, that's the first step. The second step is the court reduced that amount for present day value. In other words, if we take $180,000 over 80 years and we compress it, we account for inflation, other things, it's only about $80,000 today. Right? If I give you $80,000 today and you invested it, in 30 years it might be about $180,000. That's what we want to be looking at it. All right, you still with me? After I told you I don't care if you follow along, right? That was the second step. Then the court does something really wacky, right? The next step is just it's like he needs to go back and watch Sesame Street about math, right? This is really weird what he did here. The court assumed that in total, the couples are working 100 hours a week. I'm sorry, 100 hours per week total. What is that? The wife was working 40 hours a week. The husband was studying 40 hours a week. Is 80 plus 20 is 100. So the court assumed that in a given week, there's 100 hours of work being performed. The wife was working 40 hours, husband studying 40 hours, and husband working 20. Okay. Then the court says, well, that means the wife should be getting 40% of the assets, and the husband should be getting 60% of the assets, right? Because she's working 40 hours a week and he's doing 60. This is nonsense. It's absolute gibberish. I have no idea how the court, any people who study math or numbers, this is complete insanity, right? I have just, it's weird to come up with these numbers. But he tried something, right? In courts, you have discretion and these don't get reversed. So he just made up something. And then from these numbers, it gets even more weird, right? 40% of $82,000 is about $33,000. Okay? And then he divided it over the course of 30 years to $100 a month for 30 years. Again, if you don't get that, it's fine. I don't really care. But the judge was trying to basically get down to a simple number. I think he worked backwards, right? He said, you know what, $100 a month sounds about right. Let me just make up some nonsense going the other way. Maybe you have a better theory, I don't know. But that all this ends up at $100 a month just is real convenient. No? Yeah? It's nonsense. It's completely. He just wants to give the wife spousal support, right? The law did not permit him to give spousal support, so instead he imposed division of assets. Now again, what is he dividing? Something does not exist yet, right? There's nothing actually to divide. This is future income the husband has to spend each month to pay out to the wife. Like, what if the husband gets into, I don't know, a car accident, he can't work anymore? Right, you're basically anticipating something that may never happen. What if he dies in a plane crash? Maybe if the wife throws him off the plane or something, right? Mm-hmm. He never makes any of that money. So it's a very weird concept to divide assets that do not actually exist. Okay, that's what the trial court does here. Which again, the math is nonsense, right? But the more important point is the degree itself marital property? Whether you can divide the marital property, I think, is a separate question. But is the degree itself marital property? Who's next? Sophia, you next? Okay, Sophia, what does the Supreme Court do here?
Well, they define that marital property is kind of encompasses a lot of different things, but it has to have limits.
Okay.
So they said that a degree isn't really marital property because it doesn't have like an objective value in the market, and it's not inheritable, and it can't be transferred, and you can't buy it. So
okay,
it doesn't have all the like normal attributes of property.
Excellent answer. Very good. Thank you so much, Sophia. right? The court sort of struggles, so they don't really have a good definition of marital property either. The easy one, like Monet mentioned a few minutes ago, gifts, inheritances, they're out, right? That's not marital property. That's easy. Beyond that, it gets hard. The law presumes that just about anything can be marital property because a couple is not a robot, right? They live, they acquire, they do different things, and the presumption is it has to be broad, right? A broad definition of what marital property is. All right. The definition from the state is all property acquired by either spouse during the marriage, with exceptions. So, I mean, that's a really broad definition. Marital property embraces anything and everything which may belong to a person, but there are limits. Then they get the idea of an educational degree. They say a degree is not encompassed by the notion of property, right? Alyssa, can I sell you my law degree and might just skip the next 2 years of your life, make it much easier for yourself? Can I sell it to you?
No.
I mean, I could. I can't sell you a piece of paper on my wall.
The physical degree, yes, but not the actual title.
Can your, kids inherit your law degree one day? Can you get a refund if you don't like it? Return it to the school. Can you just write a check to South Texas for 150 grand? And say, hey, give me a diploma. Think about it, right?
I mean, that's what we're doing.
No, it's not what you're doing. No, it's not, because writing a check doesn't guarantee you get a degree, does it? They can take your money and throw you out, can't they? Yeah, they can take your money and expel you. That's actually it's actually a moral point, right? Like I feel strongly about this. I know one else not gonna like this. After 1L, a lot of you will be expelled. Not a lot of you, but a bunch of you will be. It's true. 10% won't make it back till next year. If your grades are below a certain point, you get kicked out. Why though? I think it's immoral to take someone's tuition if they don't have a prospect of graduating and passing the bar. That's why you do it, right? If your GPA is below a certain point as a 1L, it's very hard to sort of come back. And in my mind, it's sort of the point that I made to Alyssa a moment ago. Some law schools don't do that. Some law schools, oh, stick around, we'll help you, we'll get you better. And if you have no realistic prospect of graduating, it's immoral to take your tuition dollars. I mean that sincerely. It really is. So you may think people who get removed from school we're harming you. We're doing you a favor and saving you like 90 grand, right? I mean, it's not a pleasant conversation, but the degree is not just a commodity you can buy a widget for 150 whatever $1,000, right? It's something that the school can grant upon you if you meet certain criteria. So you can't just buy from the school. But I appreciate your gesture. And no, I'm not selling you my diploma. It's not worth anything. Right? It's on the wall. It's my name on it. It's not very useful. In the olden days, people would actually sell diplomas. They would just steal them and like scratch out the letters. Right? I'm serious. You ever see Catch Me If You Can with Leonardo DiCaprio? People would forge diplomas. They would take the letters and they would just sort of scratch out and they would use ink and they would put them in. I think it's harder now with computers, but what do I know? Even recently, there was a guy, was it in Louisiana or Texas, who was engaging in student loan fraud, and he would just pretend to be a student. He would just stake their identity, sign up for a student account at some community college, and apply for student loans. And he would just keep deceiving people like this. People engage in fraud. He had like 40 or 50 student loan accounts, like in various names he was profiting from. And people didn't even know they were in school, having all these loans in their names because they're government-backed loans. All right, so the court walks through a couple of reasons why the diploma is not property, why it's not marital property. First, it does not have an exchange value, right? You can't sell it on the open market. I mean, you can sell the piece of paper for a few bucks, but it's not really worth anything. The degree is personal to the student who received the education. Second, the degree terminates upon death. When you die, your law degree is no longer effective. Has no value. Right? Heirs cannot inherit the degree. Third, you can't sell it, assign it, convey it, etc. You can't purchase a diploma. And like I think Sophia said a moment ago, the degree has none of the attributes of property. Think of the bundle of sticks, it's got no sticks, right? It's just, it doesn't have it. It's sort of this weird thing that you have to acquire in life, but it can't be purchased like property. Maya? There's no exchange value. You can't sell it on the market. Glad I remembered. And this was the sort of the majority rule. Courts in other states had reached the same conclusion. In Connecticut, a court said a law degree is not a community property. Even in New Jersey, my goodness, New Jersey. We'll get to New Jersey in a bit, but in Jersey, a law degree was not community property, marital property, even where it was financed by the spouse, right? So even if the spouse paid for the tuition, literally, this degree itself is not community, it's not marital property, right? You can't seek a division of future earning potential. Some states do allow you to recover the value of the tuition, though. Some states do allow that, but you can't get future earning. Trey, is it a hand? Okay. Again, the courts in Colorado, at least, allow you to consider the degree when you're awarding alimony, right? If one spouse has a higher earning potential, but due to this weird law, the wife was not even able to accept alimony. Someone asked, wouldn't it have been better for the wife to just leave her job, get the award, and start working again? I think you lose your alimony then, though, right? In other words, an ongoing obligation. So if she ever worked, she couldn't get the alimony. And his salary wasn't even that high. It was like 16 grand. She was probably making more as a flight attendant, at least initially, but maybe his potential was greater. Not everyone with a degree makes a lot of money. You'll learn that soon. It's true. Law firm salaries are not distributed evenly, right? There are a small number of firms that pay an obscene amount of money, and the other ones not so much. That's the nature of the job. It evens out after a couple of years, right? People find it where they want to be, but at least initially, there's gonna be. It's not like a natural curve. It's like this in terms of the salary. Hanny, there was a dissent. What did the dissent say?
So the dissent would have affirmed the trial court's award, but they didn't decide that the degree itself was marital property. He just said that it was the most valuable asset that they acquired during their marriage, and had they stayed together longer, they could have accumulated substantial property.
Then what was actually distributed then, right? What was divided up according to the dissent?
He said that the wife's contributions enhance the financial status, and that she should have, as the main breadwinner, gotten an increase like alimony.
But the law prohibited that, though. Right. Thank you, Hanny. So the dissent's in a tough spot, right? He obviously feels bad for the wife. He's like, this is this familiar story, right? There's an obvious injustice here, right? The wife sacrifices for a more secure family financial future. She works to educate her husband. And what's the wife's reward? A divorce decree after the husband graduates. The court says you need to have an extraordinary remedy for this obvious injustice. What that remedy is, it doesn't really say. It's not entirely clear. He affirms the trial court. I think what he's saying is the trial court didn't abuse his discretion, so I don't have to deal with it, right? When you're in appellate court, you can say, well, discretion affirm. And that leaves the trial court ruling in place, even though the trial court ruling was incoherent, right? Just gibberish of math. All right, but the Colorado rule here is what the majority says. That's the majority rule. Okay. Questions? Yes, Kyle.
It's a common thing. Why haven't they changed?
The alimony?
Or just like the grad school thing in general, like having someone pay off your loans and then divorcing them and not being able to recover.
Well, look what happened in New York. So let me jump ahead. I'll come back in a minute. After the case, there's some notes, and they walk through the different regimes, right? In New Jersey, always in New Jersey, right? Everything's legal there, right? In New Jersey, the degree is not marital property, but the spouse can recover the money he spent towards the degree, which would be tuition, travel, etc. Right? So the advantage here is you know how much money was spent. Tuition was X dollars a year, right? So the spouse was working can get the tuition dollars back. But New Jersey does not allow future earnings to be split from the degree. New York had a case in 1905. I'm sorry, 1985, right? 1985, which held that a medical degree, a medical license, was marital property, and then the court could distribute it going forward. But then 30 years later, the New York legislature repealed it, and the court and the legislature said the degree is not marital property. So to your question, Kyle, it's actually a very good question. The New York court tried to reach the result you're talking about, and the legislature reversed them, saying no, no, no. So I think the presumption is if you are in a relationship and you're sorry, you're gonna hate me, and your spouse says, "Hey, do you want to put me through school?" Know that you may never get a penny for it, right? I mean that's what the law's saying. It's if you put someone through school, it's out of love and devotion. The same as the case from California where the husband had the stroke and the wife was taking care of him. And if you don't want to put him through, it's like, sorry, honey, go get a job. I don't care. Or put yourself through school. I'm not doing it. It's a risk though, right? Does that answer your question, Kyle? Not really, but I'll try. Daniel.
There's some sort of agreement between the spouses. It seems like a pretty good claim for unjust enrichment.
Well, that was the question from last class. Remember with the spouse and the stroke, where the court said you cannot have a contract of service between husband and wife because that's almost a antithetical to the institution of marriage, right? I see a couple hands up. Let me just make a point. What the courts are saying here is if spouse number one supports spouse number two, you better understand you're not getting anything for it, right? There's no obligation. Right? And that, again, like my friend in law school, right? The friend says, wife goes to school first and husband goes to school second. Could the husband have gotten an injunction to require the wife to pay for it? Absolutely not. It's completely between two people. It's not an arm's length transaction.
But it seems like there might be a difference between just supporting someone and actually paying for their education.
Well, again, Jersey allows the recovery of the tuition dollars. That's the outlier. That's New Jersey. The general rule is if you pay for your wife's tuition, her car, jewelry, clothes, right? Whatever you're paying for, that's not some sort of thing you can ever get reimbursed for. That's something that you do out of love for marriage. Trey? If the wife, the first thing you said, the wife what?
Do it on your own. If you take a loan out and go and then defaults on that loan, you part.
Did she co-sign the loan? I mean, look, I mean, as a practical matter, even if the wife doesn't support him, she might co-sign the loan. And if she doesn't, they could perhaps see his marital assets to pay off the loan. So again, if you're trying to get a point across, right? If you're in a marriage and one spouse wants to go to school, you're probably going to be stuck holding the bag at some point. All the stress and problems that come along with it, you have the finances as well. Sorry. Did I hear your computer? Sorry. I thought I did. Never mind. All right. Other questions on Graham? Questions on Graham? Nothing? Again, the New York case was an outlier, saying that the degree was itself a marital asset, but the legislature revoked that law. I suppose it would just have been simpler to designate an award of spousal support. Okay. Any more questions? Oh, I'm sorry, Daniel. You're at my peripheral vision. Go ahead.
The wedding ring or an engagement ring, marital property.
All right. So the engagement ring is actually tricky. It was given before the wedding, right? So the usual, well, I mean, duh, right? But it's actually an important point, right? The usual rule is something given before the wedding is not marital property. But what we talked about last class, maybe it was 2 classes ago, what happens if they break off the wedding? Who gets to keep the ring? Right? And some courts have actually said that the ring is a gift given, how do you phrase it? A conditional gift on getting married. So some courts actually hold that you have to return the ring. In other states, if let's say the wife usually gets the ring, if the wife is the one who say breaks up the marriage because let's say she adultery, right? Then she has to give the ring back. So there are various versions of the law. I don't want to go through all the different versions, but the engagement ring is a gift in anticipation of marriage, so it's not marital property. But and this is actually a tricky one, right? Let's say you give your spouse a gift of a horse or something before the wedding, and then you start taking care of the horse as a couple. That might become marital property, right? She takes to be cleaned and groomed and various other things, right? You have a pet dog. By the way, for divorce, dogs are chattel, and just about every state, there's no best interest of the dog standard, so a dog's a chattel. If numbers, you're shaking your head, no, it's true. If spouse number one had a dog before the marriage, and that spouse's dog and is divorced, then the dog returns to the original owner. Yeah, dogs and pets and divorces are the ugly ones, right? You think about kids. People fight over pets. You see that woman who cloned her dog? There was a woman recently who actually had her dog cloned, and it looks the same but different personality. That's weird. I mean, it's a genetic clone, but that's weird. I don't know. I don't know how I feel about that. It's kind of creepy. All right. What else? Other questions on Graham? One other case I read about. There was a guy in Texas who was wrongly accused. He was convicted of rape, and he was sentenced to 24 years in prison. But DNA later exonerated him. It wasn't him, so he was wrongly accused. And when he went to prison, he was married. And at some point during the 24-year sentence, the wife divorced him. In fact, that's one of the reasons why he can't divorce because he's in prison. That's a reasonable thing to do, I suppose. But he later got a judgment from the state for $6 million for wrongful incarceration, and the wife wanted to cut. She said marital property, so she dumped his ass while he was in prison, and then she wants to get paid. And eventually, this is Texas, so it's community property. The court said no. That was basically given to him from the state, and the wife did not get any percentage of it, right? So anyway, that's one last story. All right, I'm done. All right, that's about divorce. Let's go into death. The rules for death are different, right? And we'll do this question in a few moments. Right. Again, at common law, people didn't have wills, right? So when you died, you had the intestacy statute, right? Remember, the wife can take half or a third, depending if there's kids. Remember this? Okay. There are these two systems that developed called dower and courtesy. I am not going to cover them. I don't care about them. They've been abolished in every state. You can just stop writing. Right. They're confusing, and I've done them before, and they're not worth anything. So they're not worth what they're worth. So I'm just going to let it go. What I do care about, though, is what happens in a modern rule. Right. By modern, I mean the last 400 years. Right. That's what by modern. That's why I love property. Things are very long time horizons. There's a problem in property law. When a spouse dies and leaves his wife nothing. Right. If the husband has no will and he dies, then the wife gets either half or a third, right? So she's taken care of. What happens if the husband's smarter? He's like, aha, I'm going to write a will. And my wife, I don't like you. I'm not going to tell you this, but you're going to get a surprise. When my body's cold, you get surprised, you get nothing, you get zero. The wife, though, has an option. She can elect. She can choose to opt out of the will. She can choose to opt out of the will. Okay? The wife can choose to opt out of the will. This is what's called the modern elective share. The modern elective share. Modern because it's not common law, it's a modern rule. And elective because she's electing it. And share, like Sonny, no, like share, she can choose, no? She can choose to take a percentage. Okay, so what's the elective share? The surviving spouse can renounce the will. So you know what, husband, you SOB, you left me nothing. I'm opting out of the will. The wife can renounce the will and elect to take what's called the statutory share, which is usually share, which usually half, if there's half of the probate estate, if there's no children, and a third of the probate estate if there are children. And again, to be clear, that's children with the other spouse, not for prior marriage, right? If she has no children with the current husband, she can take half. And if she has children with the current husband, she can take a third. Right? The wife is basically saying, I am opting out of the will. You left me nothing. I'm going to take half. Yes, Rigger.
What about instances where the husband has children by previous marriage, but they're not wives?
Then she takes half. It's children with the current spouse, right? If the husband had 8 kids from prior marriage, that doesn't affect the current wife. Okay. And if you notice, I think I said this wrong in the earlier class. I apologize. It's not half the marital property; it's half the probate estate, right? What does that mean? It's a bigger category of things. That includes property from before the marriage. That includes separate property, a separate bank account. Right? That includes gifts and inheritances. Whatever would go through the probate system, the wife can now take half of it. It's as if he died without a will, right? The wife will take what you have had without the will, which is either half or a third.
So what is done with the remaining? Is it left?
It goes according to the will.
It does, okay.
Right? But the wife gets her first cut. The wife gets the first cut. The rest of it's distributed according to the terms of the will. Ah, yes.
Does the wife have to opt out of the will before the death?
Well, no, you can't. A will is not effective till the person's dead, right? And you can change your will at any point until you die. So that wouldn't even make much sense, right? The wife can opt out when she learns of the will after it's dead. This is what's called the probate process, right? We talk about this word probate. There's a legal process where someone, usually a lawyer, says, I have the will of John Doe, I'm going to read it. And then the wife's like, what? Right? You gave me nothing, you jerk, right? Maybe something a little bit harsher. You know what? Screw this, I'm opting out. Elective share. And it's done once you learn to the will after the person dies. One second, Daniel. It's usually, and then Caitlin, it's usually the case that when a husband writes his wife out of the will, he doesn't tell her about it because it's not a pleasant conversation. And it's more like, I'll let someone else deal with this, right? And maybe he tells his kids, oh, I'm giving everything to you, sweetheart. And it doesn't work. Daniel and then Caitlin.
Yeah, when you hear about someone executing a will, it's just the drafting
Phew.
of the will.
Right, yeah. Yeah. Well, the word to execute means we say an execution, right? The execute means to carry out, right? To put into effect, right? Literally, you're carrying out the death sentence. Doesn't mean execution. That's why that's where the phrase is from. But the executed will means that's to be signed with the formalities, the witnesses, the other thing. I did a will in the last 2 years. It's a lot of work. You have to sign so many pieces of paper. Caitlin.
So what if the survivors what if one of the spouses that didn't write the will finds out about the will before the one who wrote the will died?
Well, she can try and talk to her spouse, but she can't change his will. That's not his.
But then would she still be able to do the elective?
Sure. Yeah, the wife can say, look, you wrote this will. It's not going to work because I'm going to opt out. And that might cause husband to reconsider. Trey and then Monet. This is why, yeah. It's very hard because the wife can always opt out.
Do they follow through with writing the wife, like the attorney that's over it, with writing her out on the off chance that she doesn't know about the elective share?
Okay, so someone asked this question earlier, which is why I kind of got in trouble. There's no requirement for the wife to take her elective share. She can say, you know what? You wrote me out of your will. I don't want any of your money. Who's going to do that? But I suppose you could. Or, to Monet's point, the wife doesn't know. She's like, he wrote me out of the will. Okay. And then does nothing. So it does depend. Either the person maybe doesn't know about the elective share or chooses not to exercise it. Andres, then, yeah.
So
Joel.
when he opts out, what happens to the property that is left for someone else in the will? Like something like a bench or something that opts out.
You saying she opts out?
She opted out, so she gets half, right? But he has left other items to different people in that will.
It can get ugly, right? Because once the wife opts out, it's now up to a judge to decide how to allocate 50% of what. Who had a hand up? Joel and Armin.
So let's say they have no children, but the husband gives the wife 45%, so she's not out of the will.
She might still choose to opt out.
Really?
Yeah, I mean, she can opt out if she gets a better deal. I mean, she might think 45 is good enough, but she might choose to opt out. Armin?
Is there a time limit on opting out after the?
I don't quote me on this, but I'm pretty sure there's a probate period where the court says, any objections must be filed within a certain number of days, and that's probably your window.
And then also, is there any way to dodge the modern elective share in the will? Like, can you write like modern elective share does not apply?
No, you can't. Right? I mean, if you really want to, look, people always ask this question. If you really want to punish your wife and to sort of make sure she gets absolutely nothing, right? You can create various trusts and other things, but it's very hard under the law today. If you're married at the time of your death, your wife's going to get half. It's just that's what you can avoid it, right? And in regards, Texas is a community property state, where the wife always will almost get half or more. The common law states have sort of mirrored it. Again, the elective share, I'm putting this in caps, is only in common law states! Exclamation point. Do not, please do not say there's an elective share in Texas. There is no such thing. Because in Texas, it's community property. It's always going to be half. Right? Not always, almost always. But there's no elective share in the community property state. The elective share exists only in the common law jurisdictions. Don't screw that up, because people do this every year. If I tell you in the exam you're in Texas, I don't hear about the elective share. Okie doke. Yes, Gabriel.
When you say, because earlier you mentioned it wasn't considered common law, then you were referring to common law versus modern, now you're referring to comparative common law.
I know. Yeah. So this is the modern approach in common law jurisdictions. I heard your head right. It's the modern elective share in the common law jurisdictions. You're welcome. Right? There is no modern elective share in community property jurisdictions. So I keep saying in Texas also, so it's clear what I'm referring to. Texas does not have elective share. California, no elective share. Just remember that much. Yes, Carmen.
So there's like we did common law for common law.
Yes, a state without the elective share would be a common law jurisdiction. Hurts my mouth to say it, but it's true. Let's do some questions. Number 2, and we'll wrap up with this. And who's next? Kimmy, you next? Okay, patiently waiting. All right. So I'll call Kimmy in about a minute. So we have this question. I'll do a poll also. Husband dies in New York, which is a common law property state. He and his wife have no children. There is a child from a prior marriage, though. That doesn't count, right? During his life, the husband took out a $60,000 life insurance policy payable to his wife. Next, we learned the husband and wife bought Whiteacre worth $60,000 as joint tenants. Then we say that the husband has a separate savings account worth $100,000. And the husband writes his will. He leaves everything to his daughter from a prior marriage. Leaves wife nothing. Let's see these questions. All right, Kimmy, 2 A's for you, and everyone just take some time to think about it. Who will receive the $60,000 life insurance policy? Just take 30 seconds, think about that one. All right, another 10 seconds. All right, I'll wrap it up here. All right, Kimmy, what's your answer, my friend? Why'd you put wife? That's the right answer, right? Look at 98%. Very good. Okay, that's good. The other one's 94%. Of course, I called on one guy, put the other one in the last class. I was like, oh no, I'm in trouble. Then it's like 94%. Okay, that's fine. Kimmy, is the $1 million, is a $60,000 life insurance policy marital property? Say it louder. Why are you saying no? When does a life insurance policy pay out, my friend? So is it paid out during the marriage? Okay. So the answer is the wife. I think 99% of you, the lowly one, is wrong, right? But 99%, if someone put D also, I was kind of annoyed. The other section, A or B? It's not marital property, right? Because it's not paid out during the marriage, right? You don't get the money till the guy's dead. And it's actually dead plus some period of time because you have to do verification. You need death certificates. It's not terribly complicated, but requesting life insurance is not as easy as it should be, right? You're mourning. I had an anti recently. There's a lot of paperwork you have to do. Anyway, so the answer here is that the wife gets it. Okay. So again, the life insurance policy in New York. The rules in Texas are actually a little bit different, and we'll do that next week. The life insurance policy in Texas, the rules are different, so I'm just warning you. Isabella, 2B. This will be for you. We'll ask everyone the same question. Now I want to know about Whiteacre. Who owns Whiteacre after the death of the husband? Who owns Whiteacre after the death of the husband? Everyone, please put your answers in. You have 30 seconds or so. Hopefully you take these things down eventually. It's kind of weird. I want to hold on to it. Like on the subway or something. Brace myself. All right, Isabella, what is your answer, my friend? Okay, why you say the wife? Good. Correct. Does the joint tenancy go through probate? Does the court have to decide what happens to Whiteacre? No, why not? Correct. Very good. Yeah, 85%. That's good. The answer here is the wife. Let me explain why. With the joint tenancy's right of survivorship, immediately upon death, it goes to the wife. Immediately, right? There's no delay. The virtue of a joint tenancy is it does not go through the probate process, right? You don't have to worry about division of assets, there's no equitable distribution, etc. It goes right upon death. The kiddos get none of it, right? It goes to surviving joint tenant, who in this case is the wife. All right, now here comes the hardest one. It'll be for Pierre in a moment. How much of the savings account will the wife receive? $0, $500,000, $6,000, or $100,000? Take 30 seconds and think about it. You guys are talking. I can see. My back turned. No. Don't ask any questions. We'll answer. There are 4 choices. Pick one. I know what you're going to ask me too. I'm like, okay, scroll. I'm sorry. Well, I can't. Okay, I'm sorry. Someone's asking all these questions. The last one. Okay, I can't fit all on the same screen. I'm sorry. See, if I do it like this, they won't all fit. I'm sorry. People are going to ask me some other questions. All right, another 15 seconds. I'm sorry. That was mean. Because I was like, I can't press this and that. That's one of these questions with this one with the wife. Pick an option. You can't get it too wrong, right? All right, let's stop it here. All right, Pierre. So what'd you put?
B 50. Okay.
Why do you say B?
Because New York is a common law state, they have no children under that marriage, so technically a wife would have.
If she does what?
If she opts out of the.
She exercises her elective share. Does she have to?
She doesn't have.
So a lot of people actually put A in my other section. I was kind of surprised. But what one person said was, what the wife chooses not to do. The wife's like, I don't want your money. And she gets 0. So I think actually if to reconsider this question, it's B and probably A also are right. I think if you actually said the wife gets nothing based on the will, that's probably correct. It should have to exercise her forced elective share. Yeah, Trey and then Daniel. If it did, I'd have to give you that fact, right? So if I don't give you that fact, presume it's separate. Daniel, same. Yeah. Now the harder question, right? I think Deborah's next. Let's say the wife takes $50,000. What does the daughter get? The wife takes 50. What does the daughter get? Well, no. What does the will say? Well, the will says everything to my daughter, right? The wife takes 50,000 off the top. What does the court do then with the remaining 50,000? Give everything to the daughter. Yeah, that's correct. The daughter takes everything. Right, the daughter takes everything. 50,000 left over, right? This situation only arises because there's a will. The husband selected as heir, but the wife goes first. She takes her cut. If there's intestacy, then none of this matters because the wife takes her half and then it goes to the intestacy statute. But the fact that it's a will means the wife can opt out of it. Kevin.
Does this also happen when it comes to debt? The wife is inherits the debt.
So it's not that the wife inherits the debt, but there's $100,000 bank account. The actual debtors, the creditors would take from the $100,000 before the wife gets a penny. Right. So this sounds kind of sad, but when you have debt, before the insurance company pays anything out, the creditor's like, okay, me first. Right? They get it first. They don't go after the wife. They get it before it even pays out. So a life insurance company, before they write the check, will actually probably hear from the debtors or creditors. Here, last question. I think we're done.
What if the debt is so big that even after
Wife gets nothing?
but
Yeah,
that even if it's not paid off completely, it doesn't go to the wife.
I think if the debts are so significant, the wife might get zero out of everything. All right. Anything else? All right. Let me wrap up briefly, and then you guys can go. So far, we've been talking about the common law marriage system. We care about 2 points, right? But back up, I'm not done yet. Give me 30 seconds. We've been talking about the point of death and divorce. The rules are very different for the community property estates for Texas. So as you read for next class, just think very carefully how you distinguish one to the other. Because on the exam, I'm warning you, people are going to be in both types of states. They're going to be moving around, going from state A to state B. That makes it very complex to know both systems. Thank you so much. I'll see you all on Thursday.